Assalamu alaikum. I am Khalid AlArfaj, managing partner of Pillsbury AlArfaj. Our firm was created through the merger of a leading international law firm whose proud history dates back to the 1800s with a 100% Saudi law firm committed to becoming the best in the region. Our mission is clear: to invest in talented young Saudi lawyers working alongside our experienced Pillsbury partners so they one day become the leading regional partners in their sectors and help us build the region's leading law firm. In this video series, as we celebrate Pillsbury's entry into the Saudi market, I'll be speaking with some of our most accomplished Pillsbury partners worldwide, each bringing deep expertise in their fields. In just a few minutes, they will share valuable insights from their sectors. Stay tuned and enjoy. Today, I'm delighted to be joined by my Pillsbury partner, Deborah Ruff. Deborah serves as our global leader of international arbitration. Based in London, she brings extensive experience representing clients in complex, high-value international disputes across a broad range of industries and jurisdictions. She has acted as a counsel and advocate in arbitrations conducted under the major institutional rules as well as in ad hoc proceedings, and she is widely recognized for her strategic judgment and deep expertise in cross-border dispute resolution. Today we will be discussing arbitration as it relates to Saudi Arabia. Deborah, welcome.
Thank you.
Let's start with when advising clients at the contract drafting stage, what do you see as the most critical decisions around governing law, seat, and institution, and where do parties most often get it wrong?
Well, there are some which you might find a bit surprising. One of which is that you actually really do need to be careful that you do choose a governing law. I have seen contracts where the parties simply didn't do that. There are a few instances, of course, where choice of governing law for the parties may be limited, either by the law of one of the areas where you may want to enforce. But I have seen contracts where they simply forgot to do it. I've seen other contracts where a lot more thought really should have gone into the choice of governing law, because although there are quite a lot of articles which say, you know what, in the end, doesn't really matter what law you choose, it's all going to come out in the wash. Most laws in the end, most governing laws would come to the same conclusions. I don't think that's necessarily the case. It may be, but not necessarily. I mean, just one example is a case that I did, which was governed by the law of one of the Scandinavian countries. And it was for a contractor who had very significantly, by about 850 million euros, overrun the fixed price of the services it was providing. Now, if this had been governed by English law, there really wouldn't have been a great deal we could have done because it was very clearly a fixed price contract. But because it was governed by a Scandinavian law, which provides by process of implication of terms into the contract that both parties have started with certain expectations of fairness, of making a profit, and so on, we were able to invoke all of these and get our client 850 million euros, which is rather a large amount. So it does matter which law you choose to govern. Another thing which parties quite often do is change their minds at the last minute, because the governing law gets to be negotiated after most of the contract has been written. So again, I have instances where the clients will say, well, I know it was governed by Texas law, but it's not really going to make any difference, is it, if we switch to English law? And by the way, we need to sign this evening. Well, there may be a certain number of differences, and it really would be preferable. Nothing wrong with, with obviously with English law, for that matter, Texas law, but it would be good to have a little bit longer to consider what the effect might be. I mean, just one example, for example, is that an assignment and an ovation mean the same thing in the laws of many US states, but they definitely don't in English law. And it's just one example of many. Another one with governing law is in an effort to reach agreement, parties do sometimes produce clauses that say something like the governing law of this contract shall be the common precepts of the laws of Azerbaijan and England, or where there is no such commonality, and then they name another country because the parties are Azeri and English and they try to keep everybody happy. But you can imagine the difficulty that will ensue for either an arbitral tribunal or a judge in trying to find what the commonality is between two such very different legal systems. But leaving governing law, and there are some other very basic things that really need to be thought of very early for a contract, which will have relevance to potentially to disputes. I mean, one example is if there's any possibility that you might need to rely on bilateral investment treaty protections, which are separate from contractual protections, then you need to consider where to incorporate the vehicle that you're going to be using. And I think parties are much more aware of that now. But it is something that is important. There may be a balance to be reached between the best place to incorporate for taxation purposes and for BIT protection purposes, but certainly something you should consider. But getting to dispute resolution, well, firstly, of course, the question of sovereign immunity. If you are the non-state party, you need to be really careful that there's adequate waiver of sovereign immunity, both from suit and from enforcement, if you're dealing with a state party. You also need to think very carefully, of course, about the dispute resolution clause itself. And I see a lot of very good dispute resolution clauses, and generally I would say, however, they sometimes tend to be a bit of an afterthought. People think it should be simple, so they just shove in the one from the last contract that they signed, which may or may not be suitable. But one problem which you then have is that the clause from the last contract you signed may be inconsistent with other provisions in the contract you are now signing. But then the converse problem is sometimes people spend too much time on the arbitration clause. So generally speaking, if you've got an arbitration clause that runs to 2.5 pages, and I have seen some of those, there's a pretty high chance that somewhere in there's going to be things that are inconsistent with the rest of the contract, or even internally inconsistent with the 2 pages of arbitration clause. So I would say less is more in that sense. An arbitration clause that's more than about a paragraph is probably too long. So keep it simple. But that said, do be careful, for example, that you have specified a seat for the arbitration. Most people these days do that, and obviously that's important because it will govern what rules there are for things like interim relief, rights of appeal, and so on and so forth. Also, you really do need to make sure that you deal with the language of the arbitration. That's something people often don't think about, and many institutional rules will have a provision for it, but not all of them. And you may be doing ad hoc arbitration. You don't want to be arguing at the door of the start of the hearing which language you're going to be conducting it in. Then other things would be, do specify the law of the seat as well. And if you are opting for an institution, then make sure that you have dealt properly with the provisions of the institution, what they mandate, for example, in selecting arbitrators. So there are some institutional rules where the fallback position, if you don't specify that you can pick each party picks an arbitrator, you will end up with all of them being chosen by the institution. And since one of the attractions of arbitration is that you can effectively choose one of your judges, obviously that's not something you want to happen. But that's just a few of the things that you do need to look at.
Thank you, Deborah. So, switching to Saudi Arabia and speaking of seats, so 15 years ago, Saudi Arabia was rarely discussed as an arbitral seat. Today, that's no longer true. From your perspective, what has changed?
Well, I think Saudi Arabia has made great efforts to deal with really three challenges, or at least perceived challenges from international parties in choosing Saudi Arabia as the seat of the arbitration. One was uncertainty if you're going to have it, the contract governed by Saudi law, uncertainty as to the substantive law. There were concerns about judicial unfamiliarity with arbitration, and there were concerns about institutional immaturity, or if you were going to pick ad hoc arbitration, of what a judge enforcing an award would make of that. And certainly the government of Saudi Arabia is aware of these types of concerns and has deliberately addressed them. So it's certainly the government is keen to expand arbitration. Why? Well, firstly, it's a chance to establish Saudi Arabia's arbitral institution, the SCCA, as a venue, but also arbitration is very widely desired by international parties because it's seen as being a way of having a neutral method of dispute resolution, because regardless of what seat is chosen, the arbitrators are completely independent. So the Saudi government has gone so far as to embed arbitration in the Vision 2030. And it certainly has done a lot in order to promote it. And of course that matters, because a lot of the Vision 2030 projects, such as NEOM, Qiddiya, the Red Sea project, and so on, are all long-term, capital intensive, potentially as construction projects all over the world, potentially dispute heavy. So the government understands, and the sovereign wealth funds understand, not only in Saudi Arabia, that you need to have credible dispute resolution if you want to avoid some of the worst problems that may ensue for every very large project, and of course if you want to get investment.
So, let's talk about the Saudi Center for Commercial Arbitration, SCCA specifically. The numbers from the most recent reporting period are good, aren't they?
They are good. In fact, the SCCA has increased its caseload by over 30% just in 1 year. Now, you could say, of course, that it's going from a relatively low level, but it is moving forward very fast. That's partly, I think, because of government encouragement. It's also because the SCCA has made some sterling efforts to improve its institutional rules, to improve its facilities, and so on and so forth. There's the caseload, the nature of the caseload is unsurprising given the Saudi economy. Of course, construction and engineering disputes are the largest section. These involve complex delay analysis and arguments over liquidated damages, multi-party contracting structures. So no big surprises that there are a lot of disputes over those. And because these are complex disputes, it's noticeable that there are sophisticated parties increasingly out there who are willing to trust the SCCA. And there are now a number, I think somewhere between 20 and 25 foreign parties who have been happy to arbitrate at the SCCA, and that's expected to increase.
So what are the aims of the SCCA?
Well, it is ambitious. It aims to become one of the top 10 arbitration venues, preferably by 2030. Now, there's been a lot of debate about how and if it can compete effectively with Dubai, which of course has a longer track record of arbitration. But that said, Dubai did get some fallout from the international parties when it decided that DIAC should be the only arbitration centre available and removed the LCIA DIFC. But that said, there have been some recent surveys, such as the Queen Mary survey, which is a very well-known one, in which last year Dubai did make it into the top 10. So it will be a difficult competitor, of course, for the SCCA. But I think what the SCCA probably will do is take heart from the example of the Singapore arbitration institution, SIAC. Now that's been very successful, as we know, in becoming a regional hub, and now it's trying to move on from being a regional hub to establishing itself as a global seat for arbitration. And the SCCA, I think, is trying to take a leaf out of SIAC's book. So it's invested heavily in technology, as SIAC did. It has government backing, as SIAC does. It's doing a lot of work on raising global awareness globally, with a presence at a large number of arbitration events, lots of seminars, and I expect that it's likely to continue to do that. So how else could the government help the SCCA to get even more traction? Well, one way would be to encourage counterparties to government-sponsored or government contracts to use the SCCA in high-value contracts where one party is a government entity, or if there's a sovereign wealth fund involved. Counterparties invariably prefer either the courts or an arbitration seat which is neutral to both parties, but that said, if there's enough incentive, enough money involved in the contract, enough profit to be made, and if they are convinced, which they increasingly should be, that the SCCA and Saudi Arabia as a seat is neutral, then if you've got a large government contract to hand out, that should be fairly persuasive.
Thanks, Deborah. So a lot of legal reforms are going on in Saudi Arabia, and I remember discussing with you previously in a case, the civil transactions law. In your opinion, why this new law, the civil transaction law, the CTL, how important is it for arbitration?
I think it will be important both for arbitration, but also for contracts, whatever the dispute resolution clause may say, where they are governed by Saudi law. And this is a pretty important codification of Saudi law. It's not that Saudi Arabia, of course, is turning its back on Sharia, but before it entered into force, which is now, a couple of years ago, it was necessary for an arbitral tribunal which was applying Saudi law who weren't necessarily all familiar with Saudi law, Sharia law in any form, to reconstruct the legal principles from the Sharia maxims and from expert evidence on Islamic jurisprudence and so on. And it was felt that there was a certain amount of unpredictability and uncertainty. But having this codified in a pretty lengthy and detailed civil transactions law is going to be very helpful. It looks much more familiar to arbitrators from both civil law and common law jurisdictions, so they will find it easier, I think, to apply it. That will in turn mean you'll probably have higher caliber arbitrators accepting appointments. Probably it will mean fewer appeals or attempts to set aside awards. There are a lot of, apart from the specific provisions, there are a lot of general statements in the civil transactions law which sets out clearly various foundational aspects of it, such as a clear hierarchy, statutory provisions first, after the CTL itself. Then you look to Sharia if it's not already covered in the CTL, and so on. There is a specific reference to good faith, prohibition on bad faith. So now you know whether it's in or whether it's out. It states expressly that you have to enforce the terms of a contract unless they're in conflict with one of the mandatory provisions of the CTL, provisions for the interpretation of contracts that they have to effectively, the tribunal has to give effect. And clear setting out limitation periods, generally 10 years. And there's also a whole section that deals with construction principles, one of the major ones being the liquidated damages.
Thank you. So sticking with legal reforms, speaking about the Saudi arbitration draft law that was released in 2025, are the changes extensive from the previous law?
Well, the previous law is now a decade or more than a decade old. So it was that law, what the current law is, and was helpful in giving Saudi Arabia more credibility in the arbitration space. But the current draft law, if it's passed into law in pretty much the same form, does correct a few issues with that. It does clarify certain matters. So it's more than just tinkering. I would say it was more substantive, say, than the relatively minor changes to the English arbitration law. And it is very much in line with international expectations. So it will have specific provisions saying that the law applicable to the arbitration agreement is either that chosen by the parties or the law of the seat. There's a removal of the requirement that an arbitrator needs to hold a Sharia law degree, which was previously there. There is a specific statement that arbitrators don't need to be of particular nationality unless the parties choose to provide for that. An important one for encouraging people to take up arbitral appointments. There's the provision which is pretty standard elsewhere that arbitrators are immune from suit by the parties in almost all circumstances other than, say, fraud. And it enshrines the fundamental, what we call competence principle, i.e. that the arbitrators are masters of their own jurisdiction until and unless there's an appeal. And then there's also further provisions on interim measures, which are quite important to parties, and further clarification of the extent of joinder and consolidation, which is going to be important, particularly if there are a lot of construction disputes. And actually, one thing I should mention, because it's a clear statement of intent, is that there is an article in there which says very clearly and expressly that an arbitral award that has been rendered shall have res judicata effect regardless of the country where it was issued, and it must be enforced subject to a limited range of arguments that you can bring against enforcement.
Great. So when can we expect the draft law to be enacted?
Well, your guess is probably as good as mine, but I would say, given that the consultation period was relatively short, and given the importance of this as part of the matters we were discussing, as part of Saudi Arabia's strong efforts to modernize and to standardize in accordance with international norms, I would say probably fairly rapidly, but I don't have the inside track.
So if clients are still concerned about enforcing an award in Saudi Arabia, what would you tell them?
Well, there was concern in previous decades about that. Enforcement was somewhat uneven, but there were improvements made, again, a little bit more than a decade ago, with the Saudi enforcement law, and that improved matters because it created a specialist regime within the court system for the recognition of foreign and domestic arbitral awards. Previously, there were a lot of judges who had to deal with enforcement who really weren't familiar with international awards or indeed with non-specific Islamic arbitration. But I think it's probably not widely enough known that Saudi Arabia's figures now for enforcement of awards are actually pretty good, a lot better than a lot of countries which have perhaps a better known reputation for dealing briskly with unmeritorious applications to set aside an award. So it's about 90%. So that is a pretty good average. And the other thing is that the enforcement, the time for enforcement, there are many countries, including European countries, where you may be there for a few years trying to enforce your award despite what some of the laws say. They're honoured perhaps more in the breach than the observance. But in general, the decision on enforcement is made within weeks or months rather than years in Saudi Arabia. So, as I say, that is compares favourably with many other better known locations for arbitration.
Deborah, thank you for sharing these comprehensive insights into the rapid evolution of arbitration in Saudi Arabia. Your analysis highlights not only the structural reforms underway, from institutional strengthening at the SCCA to the codification introduced by the Civil Transactions Law and the modernization reflected in the draft arbitration law, but also the broader strategic alignment between dispute resolution and Saudi Arabia Vision 2030. For clients investing in or contracting within the kingdom, the direction of travel is clear. Predictability, enforceability, and international alignment are no longer aspirational. They are operational priorities. We look forward to continuing these discussions with our clients and partners as Saudi Arabia further establishes itself as a credible and competitive arbitral seat. Deborah, thank you again. And to our audience, thank you for joining us.
Thank you, Khalid.